Hi, I'm Tim Rountree, and I want to share with you the facts of one of my cases that was dismissed. This was a second DWI arrest for my client. We'll call her MC. She had an accident, and when the officer arrived, she was in the car and highly intoxicated. In fact, there were two empty whiskey bottles and one mostly empty whiskey bottle in the back seat, and she admitted she was intoxicated. They took her down and took her blood, and it was a 0.18, more than twice the legal limit. But we still got that case dismissed. Let me tell you what happened. The ALR hearing made all the difference in this case. That's the driver's license hearing. And at that hearing, we were able to subpoena the officer and pin him down to the fact that he did not know when MC had been drinking, and therefore he could not say that she was intoxicated at the time she drove or operated the vehicle. You see, the accident was reported at 3:30 a.m. in the morning, but the officer did not arrive until after 4:15. In order for the state to prove a DWI case, they must be able to prove that either at the time of driving you did not have normal mental or physical faculties. That means your abilities were not what they normally should be because of alcohol or a drug or some other controlled substance, or that your alcohol concentration was 0.08 or more at the time you were driving. Let's go to the ALR transcript. Now, you found 3 bottles of liquor in her vehicle, correct? Yes. By bottles of liquor, do you mean whiskey? Yes. Those bottles were open, correct? Yes. So you have no idea if after the collision she sat there drinking whiskey, correct? Correct. And you couldn't say that she didn't do that, correct? Correct. 2 were empty and 1 was almost empty. So that testimony destroyed the state's ability to use the alcohol concentration to convict her of DWI second. But we still need to rule out the fact that she had not lost mental or physical faculties that caused the collision, because that would have preceded the accident. In this case, I was able to pin the officer down and get him to admit that he had no idea why the accident occurred, so that he couldn't say that it was caused by intoxication. Let's go back to the ALR transcript one final time. I asked the officer, this was a pretty significant collision, correct? And he said, yes. Do you have any idea if she was texting? No. Or using her phone to pick a song? No. So you really cannot say why this accident happened, correct? Correct. After this hearing, we set MC's case for trial. We ordered a written copy of the ALR transcript, and on the day of trial, before the jury was selected, we showed this to the state and we persuaded them to dismiss the case. That just goes to show that ALR hearings are important. These license hearings not only are important to preserve your license, but they really help us build a significant defense in many DWI cases. If you have a question about a DWI or you need some help with a DWI, feel free to call me. I'll be glad to talk with you.